The New Jersey Supreme Court just ordered a major review of fingerprint evidence in criminal cases. The case is State v. Lee, involving 2 burglaries at a Moorestown restaurant. Investigators recovered 5 latent fingerprints near the cash register. After a database search identified French G. Lee as a possible match, an examiner used the ACEV fingerprint comparison method and concluded the prints belonged to Lee. That evidence was critical. There was no eyewitness identification, no confession, and no other physical evidence placing Lee inside the restaurant. The defense challenged the fingerprint analysis, pointing to scientific concerns about examiner subjectivity, inconsistent standards, error rates, and potential confirmation bias. The trial court allowed the fingerprint testimony without holding a separate reliability hearing. The New Jersey Supreme Court said that was not enough. The court ruled that when a defendant raises a substantial, science-based challenge to fingerprint identification, courts cannot rely simply on the fact that fingerprint evidence has been accepted for more than a century. Instead, the methodology must be evaluated under New Jersey's current standard for expert testimony. But the court did not rule that fingerprint evidence is unreliable or inadmissible. It also did not overturn Lee's conviction. Instead, the Supreme Court appointed a special adjudicator to conduct a full hearing examining the scientific reliability of latent fingerprint identification. That hearing could also determine what safeguards or limitations should apply when fingerprint experts testify in New Jersey courts. The outcome could have significant consequences for future criminal cases involving fingerprint evidence. The key takeaway is that even familiar forensic evidence may be challenged when legitimate questions exist about how reliable the methodology and conclusions actually are. If you are facing criminal charges in New Jersey involving fingerprint or other forensic evidence, an experienced criminal defense attorney can examine whether that evidence can be challenged.